Hi guys, welcome back to Lex Lumina Podcast. So today we'll be talking about trespass to person, but specifically on battery. Let us briefly introduce what is battery actually.
Battery in tort law refers to the intentional and unlawful physical contact with another person without their consent.
So basically, recently I've read a case regarding a tort of battery, which is the name of the case is about the Ahmad, Azman, and also the Rosanna Mizbun. Basically, this case is we got three situations indicates here in the tort of battery. So for the first tort of battery that occurred in this case is at which the defendant had punching repeatedly the plaintiff and caused the plaintiff to fall onto the ground. The defendant took a monopod to hit again the plaintiff, which caused the monopod to break into three pieces. Second tort of battery, this is where the defendant was forcibly took to the alien's bank in order to withdraw all her money in her bank account in a sum of 29,000 ringgit Malaysia. After the plaintiff was took to the banks, the defendant was forcibly once again to the Permodalan National Berhad office to withdraw all the money in the Amanah Saham Bumi Putra Bank. The plaintiff then in chest after knowing that staff of the PNBs stated that plaintiff only had 230 ringgit in her bank account. The plaintiff was again hit by the defendant in the PNB's office counter. Third tort of battery, plaintiff was once hit again at car park after leaving the PNB's office. So basically, for the first tort of battery, the defendant was charged in the Ampang Magistrate Court, which is the defendant was charged under section 325 of Penal Code. The second tort of battery, the defendant was charged in the Kuala Lumpur's Magistrate Court, which was charged under section 323, which is punishable under section of 326A of the Penal Code. In this case, I totally agree with the court decision. I think that the court decision which favored the plaintiff can encourage someone or the victim of the domestic violence to make a police report regarding the action that occurred in their house or in their marriage. This case can be the example of another woman out there who suffered for the domestic violence in the house, actually, which can prevent them from having a psychological damage or emotional damage in the future. Thank you.
As for my case, I want to share regarding the case of one Nur Suhaizan Binti Khairuddin against Nur Shaliza Binti Saleh. The main issue here is that the trial judge decided without judicial appreciation of evidence regarding the defects of the case. The plaintiff actually confronted the defendant's children, but then after a few moments, the husband of the defendant confronted the plaintiff because the plaintiff actually approached the children out of nowhere. So the husband want to protect his own child. So, but somehow it gets out of hand. Also involved with the defendant's wife. During the argument, it's where the battery occurs. The defendant was actually in confinement postpartum. She just gave birth, but somehow it goes to the court of appeal because of the magistrate court has some misinterpretation of evidence. So the defendant decided to appeal the decision of the magistrate court. The court decision was the magistrate court plaintiff had to pay the defendant of 305,000 ringgit with an interest rate of 5% per annum starting from 10 February 2018. And both of them had to pay 100,000 to a necessary education fees, and it was overdue because of the appeal was granted. Firstly, my comments is actually I disagree with the decision of the magistrate court, but somehow after the court of appeal, I actually agree with the decision. And the main point here is that the ignorance of the law is no excuse actually, which means a person cannot avoid liability for breaking a law by simply being unaware of it. And these are my comments, but somehow I would like to give some suggestion to both of courts. So firstly, I think one of the suggestion is rather than us file the case to the court, I think we could use ADR, which is alternative dispute resolution. So the fact that when we go to the court, the process itself is a really slow process and it took years years just for us to get the decision. My second suggestion is I think the court could use our own technology itself. So rather than us like submitting our evidence manually, the court can use technology by submitting it through online. That's all. I've recently read a case about bullying. We all know that bullying falls under battery rights. In case is about a prestigious school actually in Kuala Terengganu, where I'm from. This school is called SESMA. At 2 a.m, a minor was bullied by 5 of their seniors. The first bully punched him, and the second bully hit him in his neck and kicked him. 3, 4th and 5th bully repeatedly did the same thing. Pengawas and the penolong ketua pengawas came to the incident to see what's going on, but apparently they did nothing. Plaintiff, he was scared to tell people about all of this bullying stuff that he has been going through. So he sought medical attention on April 29th of 2015. 30th of April, a police report was disclosed. By the way, the name of this case is Ahmad Ikhwan bin Ahmad Fauzi against Mod Fahmi bin Endut and others. Decision of the case held by Federal Court Judge Ireen. The Federal Court have found sufficient evidence to establish that a parent was assaulted and has been battered by 5 bullies. Federal Court stated that have given plaintiff hearing aids as well as the compensation for all of his medication and medical fees. In my opinion, yes, they were charged under Section 323 of Penal Code. They're now free. In my mere opinion, why does the 5 bullies does not goes to jail? Why are they free? You have given innocent kid not only a lifelong trauma, but also hearing senses are gone. That's all for me. Thank you.
Today, I will summarize a case decided by the Supreme Court of California involving Deputy Aviles and also the family member of Darren Burley, which is the plaintiff. This case decided on August 10, 2020, but this case actually happened on 2012. The central issue that rise in this case are Deputy Aviles commit battery by using excessive force against Darren Burley. Second issue is, can Civil Code Section 1431.2 of Civil Code California to reduce the liability for non-academic damages based on comparative fault. So on August 3, 2012, Deputies David Aviles called to respond to a report in Campton, California. When they arrived, they saw Burley was acting strangely. Aviles pressed his knees into Burley's back using his full weight. Witnesses around said that Burley was gasping for air. Burley would never woke up and died 10 days later. So the jury found that Aviles 20% responsible. However, the trial court held that Aviles fully liable the $8 million in non-academic damages. So held that Aviles' action constituted battery. Reading the case, I fully agree with the court's final decision to hold that Deputy Aviles fully liable for the non-academic damages. What he did was intentional and not just a mistake or carelessness. Ladies and gentlemen, because I think officers must act with very careful and consideration in handling cases or suspect, especially in situations that where physical force is applied. Thank you.
So I have these cases called Muhammad Ismail Izami bin Jaafar versus Constable Muhammad Zafran Aiman bin Muhammad Zainul. So for your information, on November of 10, 2016, the police pursued the plaintiff, which is Muhammad Ismail Izami vehicle due to suspicious conduct, including an incomplete number plate and tinted window. The pursuit lasted over 31 kilometers. During the chase, Defendant 1 and Defendant 2, the Corporal Zulkifli bin Sulaiman, discharged multiple firearm shots toward the plaintiff. Plaintiff car with 14 bullet marks found on the vehicle. 2 bullets were deemed stray shoot the hit area, such as the windshield and the ceiling of the car. The plaintiff was struck in the head by the fragment, causing severe residual brain damage and lifelong complication. Claimed the defendant action constitute excessive use of force amounting to battery. So my comment, I can say that the police officer was not in the right to shoot to cause any fire upon the plaintiff, because as I mentioned previously, there was no action or harm action caused by the plaintiff to give a reasonable reasons for the police should. So that's all.
Okay, so that's all from us from the Lex Lomila podcast. See you guys in the next episode. Bye!